So I think we should start the further presentation.
Yes, sir, we can start.
Yes, yes. So till now we had covered national application phase and international, application phase of the how it works. Now I'll firstly so this the topic for this session is infringement and passing off and how can a brand secure themselves against other people who are trying to you know steal the identity of your trademark, I would say. Because once that you have filed a trademark, you have done its registration, you are using it for a couple of years, and after a couple of years, you realize that there is another brand which has only a word or a two's difference from yours, but overall, it's giving an impression that it is very much similar to your brand only. Okay. And now what you can do in those cases. So there are phases in which you can take action against such a infringing brand. Okay. So for example, you have been able to secure your registration for your particular brand, and this particular infringing trademark files a trademark application with the registry. For example, we'll just assume that the trademark registry did not object to this particular trademark for some reason, and the same is accepted by the trademark registry after a while. Now there is a 4 month of advertisement stage which happens after acceptance of each trademark, as I've shown you, and here the what happens is the trademark is advertised by the in the trademark journal for 4 months, and this gives an opportunity to third parties to oppose this particular trademark. For now, what can happen in this stage is you can file a opposition against this particular trademark so that this particular trademark does not get registered. Okay. So once we file an opposition, for example, let's suppose that a trademark is accepted and advertised. So I'll show you a couple of things which you can do to, challenge such trademarks so that they do not get accepted and advertised. So these are a couple of marks which are, accepted and advertised. For example, we'll take an example that this particular mark, that is Easy Trace, which is filed in class 10, is infringing upon your trademark, which you have already received registration for. So what will we do is we'll go to status page here. We'll click on application name, and we'll fill this particular code, which is VYWA61. Okay. So this is the particular trademark which is infringing upon your trademark, and it has been accepted and advertised by the trademark registry. So we'll check first, when was it advertised? So it was advertised on 3/2/2025. So we will calculate 4 months from this period. That is it was advertised in 3 February, right? So what we'll see do is we'll see 3 March, 3 April, 3 May, and 3 June. Up till 3 June, you have a chance to oppose this particular trademark by filing a notice of opposition. So what is a notice of opposition? Okay, I'll show you what a notice of opposition looks like. Notice of opposition is basically an application by a third party which says that, we are going to oppose this marks because this looks like our mark. So I'll show you what a notice of opposition looks like. So this is the notice of opposition. This is a notice of opposition which is filed by third party. It has a fee of 2,700 per class, and it shows the reason why they are opposing your particular trademark. So they'll write grounds of opposition in detail, and everything is given in detail, stating the reason that why do they think that your mark is similar to their marks, and all of these reasons. So once they file notice of opposition, we are supposed to file a opposition counter statement. So counter statement is basically our claim of why this particular what do I say, opposition is not good in law. That is, they do not have any claim. So we'll simply write our reasons that why our particular trademark is different from their mark. So I'll show you this example. So this is a mark agnext, AGNEXT. So a third party, when this was advertised by the Trademark Journal, a third party filed a opposition against this particular mark. So what is the opposition? On what basis have they filed opposition? Is they say that the mark is agnext is similar to their mark Agni. Now you this might look like these marks are not related to each other, but we see a lot of oppositions which are filed like this. That even there is a little similarity. Third parties filed oppositions to protect their trademarks. So what happens after they file notice of opposition is you file counter statement, and then they file their evidence, then we file our evidence, and then there is a trademark registry hearing that why this particular trademark should be allowed, should be or should not be allowed to be registered. So this is the process which takes place for opposition. So first, filing of notice of opposition, as I explained, then filing of counter opposition notice by the applicant of the trademark application. Then there is filing of Rule 45 evidence, which is filed by the opponent, showing how they have been using their mark. And then we'll file a counter evidence under Rule 46 of Trademark Rules, which shows how we have been using the applicant has been using the trademark. And then after some while the hearing happens, and the trademark registry decides whether the mark has to be allowed to be proceeded or not. So this is the first step that we can take against an infringing mark in case they're trying to get it registered with the trademark registry. Now imagine that you have a case of infringement going on where they have not registered their trademark, but they are using a similar mark, a mark which is similar to your mark. And so what we can do in this case? So we'll take an example of Beverly Hills versus Amazon case, which recently happened. So Beverly Hills is a brand, this brand, which is, being sold by, sells t-shirts, basically polo t-shirts like this. And the brand's owner are Lifestyle Equities. So Lifestyle Equities in the year 2014 entered the Indian market via Amazon. They made a certain number of sales in the very first year. Okay. In 2015, they found that they so in 2020 they found that there was an infringement happening wherein Amazon was allowing the sale of this particular trademark and these particular shirts on their website, t-shirts on their website. So from the year 2015 and 2020, this infringement was taking place. And when Amazon got to know in 2020, they filed a lawsuit against Delhi High Court, in Delhi High Court against Amazon and other sellers of this brand, saying that there is infringement happening. And they sought firstly an injunction, wherein they asked that Amazon be restrained from selling this particular t-shirt. So the court granted injunction. However, it was only recently, that is, I think a month or two back, when Delhi High Court awarded 340 crores in damages to this particular company, because this particular company was infringing on their mark. So there are a lot of details to this case, that why did this happen, why so much cost was awarded. The cost was awarded on the basis that Beverly Hills in the year 2014 to 2015 sold approximately 20-30 crores worth of t-shirts via Amazon, etc. So the court used this also as a basis to award this particular damage of 340 crores. So this is one of case of how you can take action against infringers of your particular trademark. Now, basically, what is infringement? Infringement is violation of your rights in a trademark. For example, if someone uses your trademark to sell their own goods, we see in a lot of circumstances where people put fake Nike ticks on their goods, etc., to sell their goods more. So this infringement happens all the time. And what is the difference between infringement and passing off is infringement happens in case I have a registered trademark and a third party is using my particular trademark to sell his own goods. I can sue that particular third party for infringement. Now, in case I do not have a registered trademark, however, I have a brand which I've been using for 20, 30 years, and that third party starts using this particular unregistered trademark by for selling his own goods. Then I have the remedy of passing off, which is a common law remedy which has emerged over the years. What is the passing of remedy? Passing of remedy simply means that he is passing off his goods as mine only, that they are originating from my brand. Now, since I have not registered my trademark, I cannot file for infringement lawsuit. I'll have to file for passing off lawsuit. So that is the reason it is important that whenever you start a brand, it is extremely important that you should also get it registered with the trademark registry, so that if in case anyone starts using your particular trademark for selling their own goods, you're able to sue them for infringement and not passing off. Because suit for infringement is much more easier to win than suit for passing off, because there are a lot of things that one has to establish when one files for a case of passing off. For example, when I file a case for passing off, I will first have to establish that this is my particular trademark and I've been using this for these many years, and no third party in the meanwhile has been using this particular trademark except me. And then I'll have to show how the infringement is, how the other party is using this my particular trademark. However, in the case of infringement, I do not have to establish that this particular trademark is mine, because it's already established through a registration certificate which is issued by the trademark registry. So once I show that registration, one thing will get established, that this is my particular trademark, and the registration certificate will also show the number of years for which I have been using this particular trademark. Now, once it happens, I I can easily, then show the court how this particular third party has been using my particular brand for selling their own goods, which is infringement, which is the infringement happening. So then the quantum of evidence on me for establishing the use of my brand is much more in passing off than in infringement cases, because in infringement I already have a registration with the trademark registry, but there is no such thing in passing off. Hence, it is always suggested for you to, get your mark registered. So this is the first step that you should take. Although it's sometimes brands, when they are, starting off, they may think that this is costing a lot of money, 4,500 or 9,000, it's a lot, and of there might also be additional attorney fees also. However, the importance of this is extremely good, because the reason is, even now that if you have to sell some goods on government websites like Gem Portal, etc., you require trademark registration. Even on Amazon, if you want to sell, for example, your t-shirts, if you have a trademark registration for your brand, you'll be able to sell them under registered, under branded goods. And if you do not have a trademark registration, it will come under generic goods. So the Amazon also pushes up the branded goods for, more sales. If you have a generic goods, they will not be able to, get much more sales or traction on Amazon or other such websites like Gem Portal, that is the government e-marketplace. So government e-marketplace is one of the most important market which has emerged right now, where a lot of brands are trying to get themselves registered, especially a lot of technology companies which provide physical technologies, and they want government tenders, etc. They prefer getting registration on, trademark registration, so that they can register themselves as branded companies on government e-marketplace. So this is an extremely important factor for you to consider, that why you should file for trademark registration. So coming back to, infringement again, infringement or passing off. what is the procedure that has been established by law where you can take file infringement cases. So earlier, the Trademark Act provided that in case there is an infringement or passing off going on, you can approach your local district court, and the district judge will be the one in which you will be filing the case for trademark infringement or passing off. However, what has been happening now is that the Commercial Courts Act of 2015 has changed this a bit. And now in each district, in every court, for example, there is a court in Amritsar district court, a, a judge or a bench of commercial court will be established. So in that bench, they will hear particularly matters of, matters which are covered under the Commercial Courts Act. What happens, what is the use of this is that they have been able to, fast track the process of listening to the cases. For example, if you file the cases in a under Commercial Courts Act, there are a lot of time bars which are there, that the case has to be heard in this particular manner only, and how the evidence is collected. It's all done in a very fast track method. So this is a special remedy which has been made for the general popul for the brands who want to file case against an infringing party. So what happens in the case of Amazon Beverly Hills also, the matter directly went to Delhi High Court because Delhi High Court has original jurisdiction, and uh, they filed the matter there, and in they didn't go to district court. This directly went to Delhi High Court because Delhi High Court, as I said earlier, has original jurisdiction to hear matters of such concern. And the Commercial Courts Act has also established a commercial bench in Delhi High Court and commercial division bench in Delhi High Court, which specifically hears matters which are covered under Commercial Courts Act. So this is a very good remedy which has emerged for a lot of brands because they've been able to get secure orders of injunction and damages. So this particular case of Beverly Hills versus Amazon. So this is a very famous. This has become very famous case. Although it's appealed in the division bench right now, but this has become a very important case in sense that the damages of 340 crores were. This is the first time that damages close to 340 crores have been awarded. It has happened for the first time that this amount of damages are being, imposed on Amazon, the website Amazon, because they were intermediary and they were allowing this particular infringement to happen on their website. Although there were a lot of nuances, like in the proceedings which are happening in Delhi High Court, they were, they did not appear in the matter. The matter was decided ex parte. The evidence was happened ex parte, and the court said that you are, you know, doing this deliberately, the infringement was happening deliberately, and hence the quantum of damages on you must be according to that particular thing, according to your conduct, that you were allowing this to happen deliberately on your website, this infringement. So these are the cases which are extremely important to understand. However, I'll go back to the opposition stage again, that in case you are able to get to you oppose a trademark in time, you'll be able to establish that this particular trademark is going to infringe your trademark in future. Hence, it becomes extremely important to keep a tab on the trademarks that are passed by the trademark registry so that you can keep a tab on it. There are a lot of tools which are there which can help you to keep a tab whether a trademark close to yours or which looks like your has been passed by the registry or not. So you can use them also, or you can weekly go through trademark journals, or you can appoint a trademark law firm for this particular task for keeping a tab on the trademarks. So this is one. These are several methods you can use for keeping a track of infringement. Further, you can always use Google searches, Instagram searches, for to check whether a brand similar to your brand is selling any goods or not. So these are a couple of methods that you can use. However, the important part here is to get yourself registered so that you are able to uh, establish that you have registered your trademark and you've been using this trademark for this particular long time. So filing a trademark is extremely important from that perspective. Yes. So guys, do you have any questions?
Yes, sir, I have one.
Yes, yes.
We have seen, like in my college, there are a lot of people who use like sixth copy, seventh copy of the very expensive branded products like Nike and Louis Vuitton, etc., etc. So they are being sold by various Instagram users, right? So in that way, are they infringing any trademark or it is a copyright issue? What would that
So
be?
it's an infringement issue also, and it's a counterfeiting issue also. So a lot of companies, these companies are facing an issue of, what to do with counterfeit goods, like how can, they can take action against them. So what happens is, the how that can they take action is, they will go to a court. They will say that this infringement is happening, that they are selling counterfeit goods. The court will appoint a local commissioner. The local commissioner, what he will do is, he will go to, the court will order that, you pick these infringing or counterfeit goods from this particular Instagram user's shop who is selling these clothes. And they will take, they will collect all of these goods. They will go with police and all, and collect evidence, and then, the further proceedings can take place of infringement, where damages can be established, and the amount of quantum that that particular Instagram shopkeeper has to pay. So these are the steps that they can take. So these are more or less, legal enforcement issues, that our government is not able to enforce these laws properly. And this is also an issue with these foreign brands, that they are not enforcing the laws properly. They're not going to the courts regularly, to ensure that their trademark is not misused. Sometimes they do it deliberately just to create a value of their goods in the market. But sometimes it's practically not possible for them to approach every court, to get orders from every court to, deal with these counterfeit goods. And so these are the things which have to be seen. Yes, I think I have another question. Ekta?
Sir, this is not a practical question, but academic related question. So,
Yes.
like WTO and TRIPS agreement allows software-based technological advancements to get copyrighted or even patented. Now, the same thing is not feasible in India because copyright doesn't allow softwares unless and until they have been covered with the extra technological updation, which can impact the scenario that they have a novelty. So we cannot do the same. Now the thing is, there are various fintech companies who are on the way rising in India. Now what it is that they are either using a technology that are already being available in GitHub or open source platforms, or they are using something maybe new. The protection mechanism may be new, but then they cannot copyright it or neither patent it, and unfortunately, fortunately, they have to publish it in the open source platforms like GitHub or something, the algorithm. What I felt is that this causes or likely to cause infringement, as well as infringement of the technology, as well as it might also invite cyber crimes to third party agencies, especially PaaS and SaaS softwares, like payment as a service softwares. Now, what is the remediation to the process? Is it possible that India will, because India is a member of WTO as well as TRIPS agreement, how the rules will be when our country companies are working globally, not just limited to Indian boundaries, sir?
I understand. So there is a big, so I work with a lot of product companies which make certain products online. They're software products online. So their concern is, somehow they be able to get a patent for this, so that, no third party can, exploit their idea which they have emerged, they have come up with. Although software patents, I think, are allowed in US, but they have not been allowed in India. And they, although they are allowed, but they are allowed in a certain manner, as you'll explain, that there should be physical technology attached to that, to it, to claim that, to claim that the there is a patent there. So in such cases, most of the times businesses have realized that in India, what you have to do is not that, get trademark or patent or copyright registration for these particular software products. What you have to do is, you have to sell them very well, in sense that, for example, Zomato is there, they can't patent their delivery system, or, the right that they'll be the sole delivery partners here. in India, or they'll be the only delivery app. What they can do is to sell their products, market their product in such a manner that no other party is able to sell the product in such good manner. So this is the strategy most of the businesses have realized will work in India, and this is also what we suggest to them, because taking stopping someone from using your idea, your software, or your software idea is becoming extremely difficult because of the open availability of information, and the manner in which these softwares are made. They are more or less ideas which can be made using different means also. For example, uh, if we take the example of Zomato only, so Swiggy has also been able to establish a very good model there. And then we have other third party softwares also, so companies also, which are coming up to deliver these goods. Although I understand yet you are talking about much more complex technologies. However, they are not getting recognition. They're not getting able to get patent here in India because India does not allow it. When India will allow it or not, it's more or less an academic question. I have not been able to, ponder more about that. But I can explain from my experience with a lot of product companies that they do want patent filing or patent, registered in their name, but they somehow do not come under the tests of getting themselves registered as a patent. So they fail there, and hence what we suggest them is, market the product in such manner that you know you uh, you can beat the competition, right? So this is what we suggested, because what the government will do, it's up to them, or it's in their hand. uh, what we can suggest to businesses in law is, to uh, do what you do best, in sense sell your good very well. So do we have other questions here on infringement?
So I was about to type it. So let me, this is an add-on with that. So can I suggest that get the Indian company, get your PAS and SAS, whatever it is, registered with the WIPO, and then start the business in India? Is it possible?
So there are a
Again,
lot of
domestic rules will always supersede the international rules, but still the same thing. The business, if it is a planning to launch outside the borders, then probably WIPO will save them from further infringement. So I wanted to know your recommendation.
uh, as far as patents are concerned, although it's not my domain expertise, I'm much more into trademarks and copyright. But what I will say is that the manner in which you approach for patent filing is also, in sense that there is a limitation that as an Indian national, I cannot file a patent in USPTO. I'll have to, inform the Indian Patent Office and go through a particular route which is there. So if Indian office does not allow it, uh, I cannot register directly. So even in the case of trademark also, I need to first have a trademark in India to do the WIPO filing. Okay, if I want to do the international filing through WIPO, I need to have an international application through which I'll file the international application. Although I can directly go to these countries and file an individual application there, but I will have to have an entity established there also, or make a basis of national application on the basis of which I'll do the filing there. So there is a need to have a national protection for you to approach, foreign countries. Yes, there is a lot of complexity, especially in the technology field, right? Because these are most of the times software products, that it becomes difficult to protect them. I understand your concern as, inventor of these things, or the founder of these things, because you put a lot of hard work to come up with the product, and within days someone can copy your product, your everything, and you're not able to do anything to stop them. So this is the thing that you have to do, not just good with product, but also with marketing your product or selling your product to your prospective buyers in such a manner that no other company can offer these services. So yes, so you need to focus a lot on marketing side also for dealing with the competition which can copy your ideas, because ideas themselves are not copyrightable. What you can copyright is the expression of idea. For example, if how my brand, how the my website looks, I can copyright that, but I cannot, disallow someone of using those particular ideas that I have used in my website from using in some other expressive manner. So that's the thing that with technologies and software companies, the protection is very low, but all they can do is, market their product in certain manner to be the competition. So I hope I have given some answer to your question, although there are a lot of details which, have to be discussed in this regarding patents and international patent filing, and differences between the Indian system and the foreign systems. So so uh, coming back to this here, the Beverly Hills and Amazon case. So can do you also see that there is certain similarity to both of these trademarks, right? So both of these trademarks did look alike, and in this case, Amazon was also saying that they are just merely intermediary. They are not selling the product directly. They, for example, they are not manufacturing the products. But Delhi High Court had a very different view. They say that you cannot do this like it. कि मतलब, you simply saying that you are intermediary and your responsibility won't shed away because you have taken advantage of the system and you have also made certain money from this infringement. You are also bound by the infringing acts of even third party selling products on your website. So that's the reason that the High Court awarded 340 crores in damages the to Beverly Hills here. So what we can cover here again is the what I'll show you is the practical side of opposition, that how one files opposition using the website here. I'll just log in once again and show you. So this is the IP India website again. So what I can do is go to TM file, new form filing. I'll click on file TMO. Okay. So here there are a lot of options. There is an option of cancellation of trademark, which is also there. So I'll also explain the cancellation part. So first, in case the trademark of opposing side has been advertised, then I can file a notice of opposition. I'll write the trademark application here. For example, I'll pick this particular application number and I'll put it here and I'll say apply. So they have a lot of so they have applied in a lot of classes, 6 classes. So I'll choose if I want to apply in one class notice of opposition or in certain more classes. So the more I click, the fees also increases. And here I'll upload the documents, that is my notice of opposition, which has the detailed reasoning as to why I'm filing it. And once I file it, I'll click on upload and I'll close this and I'll submit it. And then there is a fee that has to be paid after us submitting. Now if I have to file there is an important concept of cancellation of a trademark or rectification of trademark, which I want to explain here. So for example, I'm able to I filed a trademark for Reliance. I able to get it accepted, and I was also able to get it registered. That is, Reliance Industries did not file an opposition against my particular mark. So after a year or two, they realized that this is the guy named Gursimran. He was able to get registration for Reliance, and he's misusing our trademark for giving his own services. So what they will do is, because my mark is already registered, what they can do is they'll file for uh, rectification or cancellation of a trademark. So they'll write my application number here and then they will file for cancellation and give the reason as to why trademark registry made a mistake by allowing my mark to be, filed with them. How, but this is a more cumbersome process because they will have to show that by the bar of evidence is very high here. because I am a registered trademark. I've been using it for a couple of years. They didn't realize it for a lot of time, and they'll have to show that how they were, ignorant of the fact that I was able to use their particular trademark. And a lot of evidence will have to be attached. Hence, it is extremely important that once you file your trademark, you should also keep a watch on a lot of trademarks which are, being advertised by the trademark journal. So once I'll show you how the trademark journal works again. So this is, as I explained earlier, this is the trademark journal, which is issued by the trademark registry every week. It simply shows the number of trademark which have been accepted by the trademark registry. So they are advertised for 4 months, and within these 4 months, a third party has to file opposition, as I explained earlier. So I'll show you what this trademark journal looks like. So from here it starts. There is a trademark called Rockwin SQ, which has been advertised in class 1. And if I have if I have my trademark, which is Rockwin, it's ROCWIN, which I have been using, I can file an opposition against this trademark because it sounds similar to my trademark, right? And then there is this trademark which is advertised, Mahakaushal. This trademark, Prega Screen. So maybe a brand like Prega News or something like that may file, opposition against this particular trademark. Then there is Fertisoil. You know, if you have a client which has a mark similar to that particular trademark, they can file opposition against them. So you will have to, sometimes people use they physically check every trademark to see if it is similar to the trademark of their client. But now there are softwares like this which I have been using, which my firm uses. So I click on Trademark Watch. So every week it gives a list of trademark which are similar to my trademarks, and we send it to our client if they're interested in filing oppositions, and the clients revert that with their judgment of the thing, that whether this particular trademark is affecting their business or not. If they think it's affecting, they will tell us to file a notice of opposition, because this particular trademark is similar to theirs. So that's how you know uh, trademark attorneys help to uh, protect your brand. So I think I have explained how infringement, passing off, and opposition proceedings work, and how you can use them to protect your brands and trademarks and protect your business from infringing goods. So if you guys have any questions, please feel free to add it here. But I think Sanjay, I think this is all from my side. If there are questions, I'll be happy to take them, and maybe we can proceed further then. Yes, Martin.
So usually, what is the time frame for this to get resolved after you raise an opposition or any? Usually, how much time does it take? Does it drag on like? Or is there
Yeah,
any time?
once your mark gets opposed, there is a possibility that your mark will stay opposed for couple of years, if not more. The reason is that once the mark is advertised, if I file a notice of opposition on the fourth month of what do I say, the advertisement, then you have 2 months time to file counter opposition. Then I have 2 months time to file my evidence, and you have 2 months time to file your evidence. And after all this filing is done, itself takes 6 to 8 months, right? The filing process, only the filing of documents. Then the trademark registry will appoint a hearing after God knows when. So because I have been pursuing opposition for some clients for years, and I have not been able to get even a single hearing till date. And it has been more than 2 years. So sometimes a lot of delay happens. So once your mark get opposed, we usually advise our clients to maybe withdraw this particular trademark and refile the mark, and maybe then they'll not be able to get opposition, because again it's all luck again, right? That possibly the next time the opposing party might not oppose your trademark. So in that case also, you can also directly get in touch with the opposing party and assure them that you will not infringe their trademark, right? And we have tried it for a couple of clients, and we have been able to get the other side to withdraw their opposition. So after they withdraw their opposition, the mark proceeds to registration. But sometimes when an opposition is filed, the mark, it can take a lot of time to get it resolved. So some, because a year only takes for the document filing, etc., and then we have to wait forever for the trademark hearing to happen. So it's a very long process if a opposition is filed.
So then the hearing is like it's a virtual hearing, like
Yes, yes,
you
virtual hearing.
like
Everything happens virtually.
okay. So there you present
Yes.
your arguments.
Yes, we present our arguments based on the written submissions that we have made, the notice of opposition and the counter statement and the evidence. Well,
Yeah.
we can of course make further written statements also, but this is what happens. Although the hearing itself, sometimes the decision is made after one hearing only, but if it's the first hearing only doesn't come for years and years, the mark does get stuck. So I understand the frustration behind all of this because uh, a lot of people put their hard work in establishing a brand, and sometimes a lot of fabricated third party claims come and file oppositions, which results in your mark getting stuck forever. But this is how the system works here. So we'll have to, we sometimes use some alternative methods of getting the things resolved, talking to the other side maybe, and then maybe if they are professional in their work, maybe they'll be able to, respond positively to our case. So they might withdraw their opposition.
Yeah, okay, noted. So and the other thing, so you mentioned jurisdiction. So if it's a Delhi jurisdiction, it's a court of Delhi, right? Like district court.
For what exactly? For trademark filing?
Yeah, for opposition and all,
Yeah,
or
it's
court
it's
involved
it's
in that.
trademark registry Delhi office.
Okay, trademark is Delhi office. Okay, so in that, so like that, you have officers in other countries where they have local. If the local jurisdiction is of other country,
So in India, we have an office in Delhi, Kolkata, Ahmedabad, Chennai, Mumbai. So these are all the offices where they have divided the application region wise. For example, in the northern part, the applications will go to Delhi. In the western part, the applications will go to Ahmedabad, and then there is Mumbai jurisdiction. The international applications mostly go through the Mumbai office, and then for the southern side, they have Chennai, and then they have Kolkata. So
okay,
these
no,
these offices deal with the applications according to the places from which they emerge. And yes, that's the
thank you. Thanks.
yes, Sanjay. So I think if there are no more questions, I think we can conclude the session. I hope
Sir, I have one question.
sure, yes. Absolutely, yes.
Initially, the cases are opposed in the commercial court, right?
No,
Like,
the in commercial courts, the cases are filed for infringement.
okay. So if we are to oppose it, then which court decides it? The judgment is or
The trademark
hearing is like.
registry only. The trademark
Okay.
registry only. I
Okay.
showed you the
Then
website, no, from where you can file opposition.
yes, sir. Then the case, as you mentioned, like the Beverly Hills versus Amazon, as it went to Delhi High Court. When does any of such cases goes to High Court?
So I'll tell you one thing. So there are few high courts in India which have original jurisdiction to try this case, original civil jurisdiction. For example, in Punjab and Haryana High Court, I cannot directly file a case for a civil suit for infringement, but in Delhi High Court, I can directly file a civil suit for infringement by stating that the damages are more than 2 crores. So if I'm able to establish that damages are more than 2 crores, the Delhi High Court will be able to, take the matter directly in their hand. And then the process which happens in every trial court, civil court happens that, uh, the suit is filed, then written statements are filed, and then evidence is taken. So Delhi High Court is one such court where we can directly go if we are able to show that damages are above 2 crores. Okay, but
All right, sir.
otherwise, in other jurisdiction, if I'm in Punjab, for example, if I say that the infringement is happening in Amritsar, I'll go to the Amritsar District Court, the commercial court which is established there. And in case I don't get a relief from there, then I'll go and appeal in High Court of Punjab and Haryana. Okay. But that is the reason you will see that a lot of infringement cases are coming up in Delhi only, because a lot of foreign brands they try to establish Delhi as the jurisdiction, and they so that because Delhi High Court is very active in dealing with infringement matters. So a lot of international brands also prefer Delhi High Court because the judges have a lot of knowledge on infringement, and they're able to give some good judgments on intellectual property rights. Yeah, so I hope I've been able to answer your question.
Yes, yes, sir. Thank you, sir.
Do we have any other questions?
So that brings us to the close of day 2 of our trademarks workshop. A big thank you to our esteemed speaker, Mr. Gursimran Singh, for sharing their invaluable experience. And thank you all for your active participation and insightful questions. We hope you found today's session enriching. We look forward to welcome you back tomorrow. Have a wonderful evening.